And a major Supreme Court decision this week in a case challenging California's secret gender transition policies in public schools.
In a landmark 6-3 decision, the High Court restored a statewide injunction blocking the practice. NTD's Daniel Monaghan spoke with the Supreme Court and appellate litigation chief about this case.
In Mirabelli versus Bonta, parents and teachers challenged California policies requiring schools to keep information about a student's gender transition confidential from parents unless the student consents. The court says the practice likely violates both the First Amendment's Free Exercise Clause and the 14th Amendment's Due Process Clause. The ruling reverses a Ninth Circuit decision that had paused a lower court injunction protecting parental rights. The justices ruled that such secretive policies are not just administrative decisions, they are constitutional harms to parental liberty that cannot be brushed aside by lower courts.
It's been long established, and the court has in numerous opinions in the past few years really honed in that it's a long established right under the Substantive Due Process Clause that parents are able to control the upbringing of their children. And that includes the education of their children and medical decisions involving their children. So long as a parent is a fit parent, then the parent has that constitutional right. And that constitutional right trumps the ability of a young child to say, I don't want my parents to know about this.
Erin Mersino, Vice President and Chief of Supreme Court and Appellate Litigation at Advocates for Faith and Freedom, says even one of the state's own defense witnesses acknowledged the problems created by keeping parents in the dark.
So it's strange for the child to be called one pronoun at school and then a different pronoun at home. And so for that not to be cohesive is actually damaging to the child.
The High Court also pointed to a decision it issued last June, Mahmoud versus Taylor. That 6-3 ruling sided with Muslim, Catholic, and Ukrainian Orthodox parents in Maryland who argued their religious rights were violated when elementary students were required to be exposed to LGBT-themed books.
The court was very clear that the protections that they carved out in Mahmoud are broad and that they applied to gender transitions and other things that are happening in the school that parents should be allowed to know about. They should be notified and given an opportunity to opt out.
Mersino says the decision could reshape how lower courts handle similar cases.
And the Supreme Court hadn't really taken a case in this area in quite some time. And here they're saying we really did mean what we were saying back when we decided these cases, back, many, many years ago. And here we're reinforcing it now. And so I think that the Supreme Court made it very clear that the First Amendment rights of parents should be protected, that parents should be involved in the upbringing of their children, and that schools can't keep these sorts of major decisions secret from parents. And that's really what this case is about.
The court's ruling means that for now, no school district in California may conceal a child's gender transition from parents, facilitate social transitions at school without parental knowledge, or compel teachers to mislead families. Daniel Monaghan, NTD News.